Hello, everyone, and welcome to our webinar presentation, Think Before You Speak, Navigating Employee Leave Scenarios. Based on today's attendance, this is clearly a popular topic. So I want to let you know you're all part of history today, breaking our webinar record with almost 10,000 signups to listen in today. As many of you know, the topic of employee leave is incredibly complex. With a multitude of national and state-specific requirements, situational policies, and high compliance expectations, it's very challenging for employers to navigate. In today's presentation, you'll hear from two experts who will give you an overview of employee leave and walk you through some common scenarios and how to best handle them. Before we start, let me introduce myself. I'm Kimball Norup, the CEO of ComplianceHR, and I'd like to say thank you to everyone for taking time out of your busy day to join us for this important discussion. In addition to leading a great team, one of the biggest highlights of my role is participating in thought leadership events like this, along with our colleagues and legal experts from Littler. But first, a little bit of bookkeeping. At any time during the presentation today, please feel free to ask questions using the chat box to the right-hand side of your interface. Also, this presentation will be recorded, and a link to the recording and slides will be emailed to everybody who attended today, as well as anyone who signed up but couldn't attend. So please keep an eye on your inbox for an email that'll come from ComplianceHR webinars. For anyone not familiar with ComplianceHR, we're a partnership between two innovative organizations. Our solutions are powered by Neoda's AI technology and the legal expertise from the global employment law firm Littler Mendelsohn. Our purpose at ComplianceHR is to simplify the complexity of employment law and to help our clients be proactive instead of reactive with their compliance strategy while streamlining their HR and legal workflows. For those of you who aren't clients, ComplianceHR has a variety of solutions designed with employment law content from Littler to assist HR and legal practitioners with important topics like creating compliant handbooks, answering vital wage and hour, paid leave, and other labor law questions, and expert systems to evaluate common classification risks like independent contractor status and overtime. Given our topic today, I'd like to quickly highlight two solutions that we call our HR Leave Essentials. Reference Center is a solution that combines many rapid reference topics such as comprehensive guidance, final pay, FMLA, minimum wage, paid sick leave, and more, created to help HR legal and compliance professionals do their jobs more effectively. The Document Center provides you with customized federal and state compliant forms and documents focused primarily on employee leave and onboarding. Excuse me. If you would like to learn more about these solutions, we'd love to offer you a personalized demonstration, and for those interested, a complimentary free trial. It is very easy to arrange a demo. All you have to do is submit your response to the polling question that you should see on the right-hand side of your screen. A quick note, you may need to exit full screen mode to see it. Simply answer yes, and one of our compliance experts will follow up to schedule a convenient time for you. Alternatively, there's a hyperlink URL that links in the links panel to the right of your webinar interface. Or if you'd prefer assistance with your demo registration, just include your email and a best phone number in the chat box and we'll reach out to you. Finally, if none of those options works for you, you can always send an email to demo@compliancehr.com. Our goal for the demo is to understand your organization's existing strategy for compliance and any challenges you face, highlight areas of opportunity, and if we can help you with any of our solutions, we will absolutely recommend those solutions best suited for your company's needs. If you're not sure at this time, that's perfectly okay. I'll ask again once more before we conclude, or you can always just send a request for more information via the link on the screen. When the poll is running, or while the poll is running, here's a quick teaser of how these solutions can support your compliance team's leave strategy. On the left, you'll see a list of the forms offered in the Document Center. In the center of this screenshot is an example of our general requirements for California's FMLA policy as an example, including a breakdown of the federal and state eligibility, Finally, on the right is an example of one of our newer reports, the Paid Sick Leave Report. This offers a side-by-side comparison of paid sick leave policies across all U.S. jurisdictions, ensuring your team can easily and compliantly implement these policies. So again, if you're interested in seeing a quick demo, just select yes on the poll or click the link on the links panel. Okay, now it's time for the main attraction. It's my great honor to introduce you to today's presenters. Rocio Blanco Garcia is a shareholder in Littler's Miami office. She counsels and represents clients in a broad range of labor and employment law matters, which of course includes the topic of employee leave. Lauren Robertson is a Littler associate based out of Littler's Orlando office, with experience litigating employee leave cases among a variety of other employment law issues. These two experienced attorneys are truly experts on today's topic. So Rocio and Lauren, thank you so much for presenting today, and I will now pass it over to you.
Awesome. Hello, everyone. Thank you for being here with us today. Those of you who have attended my presentations before, and I think there might be a few of you here, know how much I love doing these things and that I try to be a little bit unconventional. I do not, we don't want to just bombard you with law, but we really want to give you practical advice, and that will be our goal today. We're going to do a quick refresher. Lauren primarily will walk you through some reminders on FMLA, ADA, and also the Pregnant Workers Fairness Act that went into effect last summer. And then we will quickly move on to actually doing case studies. We will present you with a series of scenarios, and we will tell you how we will walk through those scenarios if presented with them. Our goal is that this will help you issue spot and that it will help you see how we do it so that you can try to emulate this in your workplace. But before we go further, first things first, the fine print. We are lawyers and we love a good disclaimer. So we only have a 1 hour or 50 minutes of your time today, which means that we will not be able to cover everything that there is to know in the world of FMLA, ADA, and Pregnant Workers Fairness Act, right? If we could do so, then the topics would not be nearly as difficult as they are in reality. So we're just going to give you a primer, and again, we're going to walk through those scenarios, but just keep in mind that in addition to anything that we teach you here today, you're going to have to always consider your own state laws, right, depending on where you are. If you are in California, that's going to be very different from Florida, and it's going to be very different from Massachusetts or New York. So in addition to anything that we teach you here today, always remember to go back to your specific state so that you can make sure that you are also looking at that in analyzing these leave issues. All right, without further ado, let's jump right into our refresher. Lauren, can you tell our friends here today about the FMLA?
Yes, thanks, Garcia. So why is the FMLA so different from any other law? First of all, its significance is that it protects an employee's job and their benefits. So an employer cannot take any action against an employee because they've taken FMLA leave. And there is also an obligation when they're done with FMLA leave, with some exceptions, of course. For example, if someone is deemed to be a key employee, to return the employee to the same or equivalent position. FMLA does not provide job protection in all instances, though. So if an employee would have otherwise lost his or her job while actively working, for example, a layoff, then there may be some exceptions as well as to why you do not need to reinstate an employee. The FMLA also protects an employee's benefits. So group health benefits must be continued during the time that an employee is on FMLA leave. If FMLA does not apply, the employee's benefits are not protected unless protected by your employer's policies or plans or otherwise required by state or local law. And their job function is now a function of the company policy and ADA, which Rocio will discuss in a few slides. Leave may be taken continuously or intermittently. Examples of intermittent leave is leave taken on an occasional basis for medical appointments, leave taken several days at a time over a period of 6 months, prenatal examinations, etc. The FMLA is also unforgiving in the sense that there is no operational hardship defense to providing FMLA leave. If an employee is eligible, then the employer needs to provide FMLA leave to the employee. So how do we know if an employee needs leave? There are no magic words. An employee does not need to specifically state, "Hi, I need FMLA leave," and reference FMLA leave when requesting leave to specifically invoke a request or trigger or put the employer on notice of the need for leave. So some examples may include an employer realizing that an employee's timesheet or hours worked report looks different than usual. So maybe she's taking longer lunch breaks, coming in later, leaving earlier. An employee who has poor attendance that is about to lead to discipline if the employee has otherwise had perfect attendance in the past. Employee raising an issue about her work schedule as it relates to a medical condition. Maybe this employee has back pain and is a manager of a retail store and has duties to supervise employees on the floor. Then that employee may be requesting that she needs to take time away from those duties that require her to stand. An employee explaining during the course of a counseling or disciplinary meeting that he has a medical problem causing the performance deficiencies. Additionally, an employee who provides information either in person, via telephone, from a family member about a medical problem that may require some time off work. So for example, if an employee happens to get into a car accident on their way to work and then that they're taken to the hospital and their husband then notifies the employer that they're now being transported into surgery, that would put the employer on notice of FMLA leave. A manager notices a significant change in an employee's behavior, work patterns, or conduct and has reason to believe they may be related to a medical condition, or an employee has an on-the-job injury which renders him unable to work for a period of time. Now, this is not an exhaustive list, but as you can see, there are a variety of ways in which an employer can be put on notice of the need for FMLA leave. So who is eligible and when does the FMLA apply? Well, the FMLA applies to covered employers with 50 or more employees within a 75-mile radius. Independent contractors do not count towards that total. And as far as who is an eligible employee, the employee must have accumulated 12 months of service and have worked 1,250 hours in the last 12 months. Breaks in service may count. Time out for workers' comp injury counts towards the 12-month service, as well as non-FMLA leave that can transition into FMLA leave may count. So for medical reasons for FMLA leave, the FMLA permits an employee to take leave for the birth or placement of a child, to care for a spouse, parent, or child with a serious health condition, or for the employee's own serious medical condition. The FMLA does not require an employee to demonstrate that no other caretakers are available before obtaining leave for purposes of caregiving leave. Moreover, an employee may take leave intermittently if care responsibilities are shared with another member of the family. Fathers as well as mothers are entitled to FMLA leave to bond with a newborn child, a newly adopted child, or a child placed in the employee's foster care. So what is a serious health condition? The definition of a serious health condition, as you can see on the screen, is very broad. In short, just about any medical condition can be a serious health condition, as defined by the FMLA. Employers are forced to determine whether an employee or an employee's spouse, child, or parent has a serious health condition, and how an employer makes that determination will be based on a case-by-case basis. Generally speaking, an employer makes this determination by requiring a certification from a healthcare provider that an employee or an employee's spouse, child, or parent has a serious health condition, as evidenced by how the healthcare provider fills out that paperwork. The FMLA also defines child broadly, not only to include biological, adopted, or foster child, but a stepchild, a legal ward, or a child of a person standing in locus parentis who is either under the age of 18 years or is 18 years of age or older and incapable of self-care because of a physical or mental disability. With respect to the definition of parent, it's important to note that the FMLA does not apply to in-laws. So, Rocio, what if the employee cannot come back to work after 12 work weeks?
All right, so somebody in the chat actually asked us to cover this, so it's your lucky day because it was already on our agenda. So many times, a person will need leave before they're even eligible for FMLA, right? Like it could be that they have not been with the company for a year, that they have not worked 1,250 hours, or that the company itself does not have 50 employees within a 75-mile radius, so FMLA does not apply. What do we do with that employee? Do we just fire them? No. We have to engage with them in an interactive process under the Americans with Disabilities Act. And the reason for this is that the law and the EEOC regulations of the ADA clearly tell us that leave can be a reasonable accommodation under the ADA. So if a person has a disability, as that term is defined under the law, and it is defined quite broadly, and depending on the state, it's defined even more broadly, we're going to have to send out a questionnaire, get more information from the healthcare provider, and if the healthcare provider substantiates that there may be a need for leave, then unless it is an undue hardship, we're going to have to provide it. And the reason for that is that the Americans with Disabilities Act prohibits discrimination because of a disability or a history of a disability, or because someone is associated with a person who has a disability, or that person is perceived as having a disability. And one of the things that the ADA requires us to do is to reasonably accommodate qualified individuals. And again, leave may be considered a reasonable accommodation. So we can't just swiftly move to termination if an employee does not qualify for FMLA, or if the employee fails to return after the 12 work weeks of FMLA, because we still need to make sure we check this box in the process. Now, earlier, Lauren mentioned that when a person qualifies for FMLA, we don't care how inconvenient the leave may be for the employer, right? Like it could be that you feel that your business is gonna, really suffer if the employee is not there. If the employee qualifies for FMLA, you have to provide it no matter what. Under the ADA, it is different because we do have this exception where you do not have to provide accommodation if it will be an undue hardship. Now, I sit through countless calls every week with clients who tell me, oh, it will be an undue hardship. I don't just take that at face value. Our job as employment counsel and as HR professionals is to dig in further. And when a person is telling me that something is an undue hardship, I have to ask follow-up questions. Why is it an undue hardship? Have you done this before? How did you make do when you did this before? What has changed from the previous time that you allowed this? Why did you allow this other employee to do this and now you're not allowing this other employee? Are there any alternatives that we should be considering? Because if we are going to waive the undue hardship flag, we need to be ready to substantiate that with actual data. And there are 6 facts that really can kill any undue hardship argument. If you have a policy that specifically says, that you may grant leave of that length, it's going to be very difficult for you to say that now a leave of that length is an undue hardship under the ADA. If the employee has previously taken these types of leave without incident, you're going to have to show a material change in circumstances that will justify you now saying that the same type of leave that the employee has taken before will be an undue hardship this time around. If during the employee's absence, We have been able to successfully cover our business needs by maybe positioning other employees in the role, by hiring temporary staff, without really suffering, tremendously, then that also will kill an undue hardship argument. Another thing that will kill an undue hardship argument will be terminating the employee right before the employee is scheduled to return. Sometimes we get doctor's notes from employees that say, I'm going to be returning in 2 weeks or 1 week, and then we move to terminate at that point. That's going to look terrible, right? Because what is your undue hardship? The person was already out on leave. How do you justify terminating them now that they're about to come back? It's going to look retaliatory. It's not going to justify an undue hardship finding. And then another thing that I see all the time is business tell me, well, we can afford to not have anybody in that role for 2 weeks or for 3 weeks, so we're just going to terminate him. But think about it. How long does it take you to replace an employee, right? Between posting the job, interviewing the candidates that you find, then onboarding them, and then those candidates may have to give notice to their to their prior employer. The reality is that you're probably not going to get somebody in that quickly. So you have to keep in mind, is it going to take me longer to replace this employee than it is going to than just letting the employee be out on leave? Those are questions that you need to be asking yourself as business people. And these are questions for those of you in HR that you need to be asking the managers on the field. Because if they're not able to answer these questions, it's going to be very difficult for you to come up with the data to be able to say that something is an undue hardship. So the moral of the story here is, do not just take the manager's words at face value when they tell you something is going to be an undue hardship. Push back. Ask for actual facts. Ask for data. Make sure that we will have an arsenal of data at our disposal if somebody comes back and challenges that undue hardship decision. All right, Lauren, now let's talk about the Pregnant Workers Fairness Act that came into effect last year.
So the Pregnant Workers Fairness Act is a recently enacted law that requires employers to make reasonable accommodations to known physical or mental conditions of employees that are related to, affected by, or arising out of pregnancy, childbirth, or pregnancy-related medical conditions. The proposed Pregnant Workers Fairness Act regulations rely heavily on the concepts with which the employers are already familiar of because of their ADA compliance efforts. For example, the Pregnant Workers Fairness Act adopts some of the ADA's definitions, including undue hardship, essential job functions, interactive process, reasonable accommodation, and individualized assessment. So for all intensive purposes, employers generally will be able to use their ADA interactive process procedures for pregnancy-related conditions. Employers, however, will want to ensure any employer request for supporting documentation, though, is consistent with the regulations, and I'll touch on that in a few slides. There are some instances that the EEOC has noted that the accommodations, which are termed as predictable assessments, will rarely be an undue hardship and should be granted in virtually all cases without requiring supporting documentation or extensive individualized assessment. And those include an employee to carry water and drink in their work area, allowing additional restroom breaks, allowing the employee sitting in jobs that require standing, and standing in jobs that require sitting, and allowing breaks as needed to eat or drink. So what do we mean by related medical conditions? The EEOC identifies a long list of medical conditions that it characterizes as pregnancy-related, some of which are not immediately evident to employers. These conditions include infertility and fertility treatments, past pregnancy, endometriosis, birth control use, menstruation, miscarriage, stillbirth, having or choosing not to have an abortion, postpartum depression, lactation and conditions related to lactation, such as low milk supply, and post-pregnancy limitations or complications that are the consequence of pregnancy. So that the way the EEOC has interpreted the Pregnant Workers Fairness Act, they've interpreted the term related pregnancy medical conditions so broadly that it almost is being construed as far as European law is providing protection for pregnancy-related conditions or menstrual leave. So is the Pregnant Workers Fairness Act just another version of the ADA? No. Despite its reliance on the ADA's definitions in most instances, the Pregnant Workers Fairness Act departs from the ADA in several respects. Most importantly, the Pregnant Workers Fairness Act deems an employee qualified for a position and thus requires employers to accommodate an employee even if the employee cannot perform an essential function for a temporary period, so long as the temporary inability to perform the essential job function is such that the employee will be able to perform that essential job function in the near future, which the EEOC defines as about 40 weeks from the inability to perform that specific essential function. The proposed regulations from the EEOC do not set one overall 40-week limit for all job functions. Instead, the EEOC takes the position that an employer should consider the in the near future 40 weeks to apply to the inability to perform each function separately. So, for example, an employee may not be able to perform an essential job function during pregnancy, which triggers a 40-week time period, and be unable to perform a different essential function because of a post-pregnancy, pregnancy-related medical condition, triggering another 40-week period. Another important distinction, like I mentioned in a few slides prior, is that the ability to seek documentation may be limited in some circumstances. The EEOC has taken the position that employers may not seek supporting documentation if the limitation and the need for reasonable accommodation are so obvious and the employee self-attests, when the employee or applicant has provided the employer with enough information to substantiate the known limitation and the need for accommodation. If the accommodation is one of 4 listed as a predictable assessment and the employee self-attests, or if the accommodation is related to lactation or pumping and the employee or applicant self-attests. In other circumstances, documentation would be limited to documentation that is sufficient to describe or confirm the physical or mental condition that is related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions, and that a change or adjustment at work is needed. Another and the final major distinction between the ADA and the Pregnant Workers Fairness Act is that an employer must make a reasonable effort to accommodate the employee in their current role, and that providing or giving the employee as an accommodation, paid or unpaid leave, should be used as a last resort accommodation. So now that we have covered or given a refresher, we're now going to move on and apply some of these principles to practice.
All right, so this is probably my favorite part of this training because it's quote-unquote hands-on, right? But before we move there, I just want to emphasize that last point that Lauren mentioned, that under the Pregnant Workers Fairness Act, leave is more of an accommodation of last resort. Somebody asked whether leave was a reasonable accommodation under the Pregnant Workers Fairness Act in the chat, and that's the answer, right? Like you should try every other possible thing before you resort to leave, because otherwise, the employee is going to be out of work, out of pay, and we're trying to not cause that for parents or, soon-to-be parents. And then somebody else asked, and I picked this question, just so you guys know, we have already received about 300 questions, so it's very difficult to answer all of them. So I'm just seeing some that are popping up and picking those, but we will try to answer all of them after the training. Somebody asked, under the Pregnant Workers Fairness Act, do you need to accommodate an employee in the event the employee cannot find childcare for their newborn child? I get this at least once a week, where an employee comes and submits paperwork saying, oh, I need to be accommodated because I don't have childcare, or I need to be accommodated because I am breastfeeding and my son or daughter will not take a bottle. Well, the law is not quite that broad, right? You still need to come back to work. You are not going to be accommodated because your son or daughter refuses to take a bottle, and you're not going to be accommodated because you do not have child care. Those are not known limitations of the pregnancy. Those are limitations that you are suffering by virtue of your personal circumstance, not the pregnancy, right? So the short answer there is that if that's all the employee is giving us, then the employee is not going to be accommodated. What we often see, though, is that then the employee goes to the doctor, and then the doctor writes like something about like postpartum depression or baby blues, or the employee is experiencing this other, mental health condition, and then they end up getting accommodated because of something else that now has substantiated a known limitation. All right, so let's...
Rocio, just really quickly, another question that I wanted to highlight from the chat was an employee who has been employed for 30 days and presents with a request for accommodation under the Pregnant Workers Fairness Act. Are they eligible? And the answer is yes. The duty to accommodate a pregnant employee applies not only to applicants but to employees. And so there's no years of service required in order to trigger an employer's duty to accommodate an employee. So it wouldn't have mattered if you had become aware at the time that the employee applied for the position that she would have needed a potential accommodation, or after the fact, you're still required to accommodate.
Yeah, and we've actually seen a few of those too, right? Well, more than a few, where the employee starts working and then the manager's like, oh, I didn't know she was pregnant. We need somebody right away. Now she's asking for all these kinds of accommodations. Well, too bad. It's just the situation that you have to deal with now, because the Pregnant Workers Fairness Act will create an obligation on that employer to accommodate unless there's an undue hardship. All right, Lauren, shall we go through scenario number one?
Sure. So scenario number one, let's set the stage. John calls you and tells you he has been hospitalized due to hypertension and heart issues. He will need to remain at home for 3 weeks and has been advised to avoid stressors, including work. John is 2 weeks shy of his 1-year work anniversary. John State does not have its own medical leave statute. This is your busiest time of year as the employer. Rocio, what do we do?
All right. So the first thing I would look at is whether John is going to be eligible for FMLA. So here we know that he's not eligible because he has not yet worked 1 year, right, which is one of the requirements. But assuming he has worked 1,250 hours and that this employer has 50 plus employees within a 75-mile radius, we know that John is about to become FMLA eligible in just 2 weeks. So since he's not eligible for FMLA, then I move on to considering ADA. So this is your busiest time of the year, so you might be inclined to tell me, well, this will be an undue hardship and we cannot accommodate him. But if you were to tell me that, that could be very, very problematic. Why? Well, he's about to become eligible for FMLA in just 2 weeks, as I mentioned. And once he's eligible, it will not matter how inconvenient this is to you. You will have no choice but to give him leave at that time. So if you are going to make an undue hardship argument, you are going to have to convince a jury that you could not have, under any circumstance, done without John for 2 weeks. And that will be very difficult to prove. First, it is going to take you longer than 2 weeks to hire somebody else to replace him. So practically speaking, posting the job, interviewing the candidates, and onboarding whomever you select will take longer than those 2 weeks. Second, how do you plan to cover his absences once he's eligible for FMLA and you have no choice but to give him the leave? Whatever you're planning to do then, you should just implement 2 weeks earlier so that you can accommodate him under the ADA pending his FMLA. Now, quick question. I get this all the time. Once he becomes eligible for FMLA, can you now retroactively designate the 2 weeks that you gave him as an accommodation under the ADA so that the clock was already ticking under FMLA and now you don't have to give him a fresh set of 12 weeks, but rather 10 weeks because you have already designated the 2 prior weeks as FMLA? The answer is no, you cannot do that. You can only retroactively designate time that will have qualified as FMLA. And these 2 weeks, as we just went over, do not qualify as FMLA because he has not been employed for a full year. So what ends up happening here is that John will end up being accommodated with leave under the ADA for 2 weeks, and then he will get a fresh set of 12 work weeks under FMLA. Under the fact we're told he only needs 3 weeks total, so, it won't matter. He'll come back. But if for whatever reason he ends up needing more time, he will get a fresh set of 12 work weeks under FMLA. All right, scenario number 2.
Mary joined ABC Corporation 2 months ago. She works on site as a care coordinator for a healthcare facility. Although she interacts with care providers every now and then, her work primarily involves speaking with different parties over the phone. She walks into HR to announce she is pregnant and will need to work from home because she has not been feeling well due to her pregnancy. Rocio, what do we need to do first?
All right, so step 1 here is determining, again, is this employee eligible for FMLA? I got confused with fact patterns. Okay, so she has only been there for 2 months, so we know she's not eligible for FMLA, right? So even though as a general matter, when you reach out to me for advice and counsel on FMLA and ADA, I will always ask you, how long has the employee been employed and where is the employee working? And the reason why I'm asking that is because I first want to determine whether the employee is eligible for FMLA. Here again, we know that she's not eligible for FMLA because she has only been working for 2 months for the company. And if we were in another state where there might be more flexibility or more generous leave policies, then that might change the outcome. But we're focusing on FMLA, federal law, for purposes of this training, and here we know that she doesn't qualify. Now, her manifestation that she has not been feeling well due to pregnancy should immediately be a trigger for you to think of the Pregnant Workers Fairness Act. So at the beginning of this training, we told you all that we were going to, try to train you a little bit on how to spot triggers, issues that you need to be addressing. And here, if you have an employee coming to you mentioning a pregnancy and not feeling well, that should be an automatic trigger in your head to start thinking of Pregnant Workers Fairness Act. What I would therefore recommend you to do in that situation is that you prepare a questionnaire and give it to the employee for her doctor's completion so that we can determine if she has any known limitations of pregnancy. Now, the questionnaire that I sent out under the Pregnant Workers Fairness Act has some similarities with a questionnaire that I will send out under the Americans with Disabilities Act, but it is not the same. So if you do not have one already prepared and you need help with that, reach out to us. Or if you are unsure whether you are asking the right questions, also reach out to us. We can help you through that. But there are similarities with the ADA, but as Lauren already explained to us, it's not the same thing. So my first step here, after I determine that there is no that there is a pregnancy issue, is going to be to prepare that questionnaire and send it to the employee. Lauren?
Scenario number 2 continued. So Mary's provider fills out paperwork stating Mary has been experiencing severe morning sickness and often feels lightheaded. The provider recommends work from home for the duration of the pregnancy. You learn that 2 other employees in Mary's role, but reporting to another individual work from home, one due to seizures, the other because she moved 2 hours away during COVID. But she is awesome, so we allowed it. Rocio, what do you do? And just before you answer that question, I have been trying to answer some of your questions in the chat. So to the extent that I'm not able to get to them, we'll try and answer them at the end of this presentation. But just wanted to flag that for everyone.
Yes, there's a lot of them. So, we can only type and talk so quickly. But, all right, so now we have the paperwork. We have sent out the questionnaire. She has given us back the paperwork. And the provider has actually given us information that she is experiencing a limitation of pregnancy. She is having severe morning sickness, and she's lightheaded. So that is going to be covered by the Pregnant Workers Fairness Act. So we now need to, as part of the interactive process, determine whether we're going to be able to accommodate this request. Here, I could have theoretically pushed back on the provider and asked whether there are other alternatives besides working from home, such as, for example, more breaks during the shift, easier access to water, allowing her to lift her legs. I could have pushed back and asked for other alternatives if I believe that on-site work is really important. However, the problem I have in this particular scenario is that there are two other employees I am letting work from home. And particularly problematic is the one that is working from home because she chose to move away during COVID-19, which we see all the time. So how am I going to justify not giving the accommodation of at-home work to this employee, or even potentially pushing back on the questionnaire when I am letting this other employee do the same exact job from home just because she chose to move away? So one of the morals of the story here is that good deeds usually do not go unpunished. And when you're going to do something for one employee, you have to think about the impact that could have down the line in other situations. So when the employee moved away and we let her work from home, we opened some floodgates that will now keep us from being able to argue that it will be an undue hardship to now allow this other pregnant employee to do the same thing, i.e. work from home. So be careful when you are looking at employee situations. Do not just look at the here and now, but also analyze how things play out. The ADA, FMLA, Pregnant Workers Fairness Act, these are all very fact-specific issues that need to be analyzed very, very carefully. And we need to focus on the facts of each particular case. But I will ask you whether you are accommodating somebody else or allowing somebody else to work from home, and I will expect you to be able to explain what the difference is between this employee and that other employee so that I can feel comfortable saying that you are going to be able to survive a challenge to a denial of a requested accommodation. All right, scenario number 3.
Jane is a single mom. Her son has autism. She needs to take her son to therapy every day from 1 to 3 p.m. Her usual schedule is 9 a.m. to 5 p.m. for a total of 40 hours per week. She has asked for flexibility in her schedule. Jane wants to work 9 a.m. to 1 p.m., take a 2-hour break from 1 p.m. to 3 p.m., and then resume work from 3 to 6 p.m. This flexible schedule, if granted, will result in her working 35 hours per week instead of 40. Rocio, what do we do?
All right. So the first thing that I encountered when I get this type of question is the employer tells me, oh, do I need to accommodate under the ADA? And the answer is no. This is not an ADA issue, because Jane is not asking for an accommodation for a flexible schedule as a result of her own disability. Rather, she's asking for it because of her son's condition. And an employer is not obligated to accommodate a family member's condition. So we cannot discriminate against Jane because of her association with her son who has autism, but we do not have to accommodate her because it has to be the employee's own disability, not a family member's. So, not an ADA issue. Is it a FMLA issue? Absolutely. It certainly is. Remember earlier, Lauren explained to you all that FMLA allows employees to take leave not only because of their own serious health conditions, but also for the serious health conditions of certain family members, including children. Now, we do not have enough information in this fact pattern to know how long this employee has been with the company and whether she qualifies for FMLA. But let's assume that she has been there long enough and otherwise meets the eligibility criteria. This issue falls squarely within FMLA. And you're going to have two options. First, you could grant the flexible schedule, not because the ADA requires you to do it. Again, it does not. But because you want to be the employer of choice. You want, out of the goodness of your heart, accommodate this employee who is going through a tough time. Or you can choose to not grant the flexible schedule, which you do not need to do, right? And require the employee to take FMLA for any time off that she's going to need as a result of her son's therapy session. Now, a few notes on each option. If you go with the first option, the one where you accommodate out of the goodness of your heart because you want to be an employer of choice, just please keep in mind the precedential value of this decision. You might be required to do the same for others who are similarly situated to this employee in all material respects. And keep in mind that even if you grant the flexibility, the scenario is telling us that the employee will end up working 35 hours instead of 40. That 5-hour deficit needs to be designated as FMLA. No buts, no ifs. Even if the employee tells you, oh, I don't want to be that to be counted as FMLA, you are required to, any time off that is necessitated by as a result of an FMLA qualifying reason, you are supposed to designate it as FMLA. So that 5-hour deficit needs to be designated as such. Now, if you go with option number 2, meaning you do not accommodate out of the goodness of your heart and you just require the employee to take FMLA, that is totally fine. And what will happen here is that the employee is going to exhaust FMLA faster than she would have if you had given her the flexible schedule. And once she exhausts FMLA for this situation, she's not going to be entitled to an 88 accommodation because it is just for her son. And then at that point, you're going to have to make the decision of whether you want to terminate employment or not. All right, scenario number 4.
Employee wanted to take vacation around Labor Day, but was out of vacation time. Employee submitted FMLA paperwork to cover their absence for back pain, which was substantiated by an MRI and CT scan. Paperwork showed the employee to be completely incapacitated for 3 weeks. The employee attended a medieval festival and went bar hopping with friends who took pictures and posted them on Facebook. The employee also posted them. Employee's coworkers and Facebook friends felt betrayed having to cover her work, brought the photos to the attention of the employee's supervisor, who was also a Facebook friend. What do we do?
So this is dealing with a situation of abuse, right, of potential abuse of FMLA. And the key here is to gather the information you have about the employee's use of and reason for the leave. You want to evaluate whether the employee's conduct is truly in conflict with the reason for leave, and basically don't be too quick to judge or assume. Once you look at the information, you look at what the FMLA certification form stated, and you try to determine whether the conduct at issue is truly in conflict with that certification, then you will want to confront the employee with the conflicting information and ask questions, and then make a decision based on the totality of the circumstances, including the employee's own explanation of their conduct. You always want to proceed with caution here. And the reason for that is I have had many times where clients come to me and tell me, you know, so-and-so has been on FMLA for depression, but we just saw pictures of him at a resort in Mexico. Well, is really a vacation in Mexico inconsistent with a certification that the employee has depression? Not necessarily, right? Like, I think a retreat in Mexico could do the soul some good if you're depressed, right? So we cannot, I understand the instinct to feel like, you know, what the heck? Like, this employee's out. We're having to pick up, you know, the work and have other employees work extra because he's on FMLA and now he's in a resort in Mexico. But if the conduct does not truly conflict what the certification says, we cannot be too quick to pull the trigger. So we have to investigate and proceed with caution. All right, scenario number 5.
Mary works in the warehouse of a trendy furniture store. While lifting some boxes, she feels a sharp pain on her back and falls to the floor. The injury is reported using the company's usual workers' compensation protocols. Mary takes a 4-week leave of absence and is released back to work with a 10-pound restriction. What do we do?
All right, so many times people think, oh, on-the-job injury, workers' comp takes over. Yes, workers' comp takes over, but we cannot forget about the interaction with 88 and FMLA. If you're out of work on workers' comp, that time should be simultaneously coded as FMLA because you're out on a serious health condition, and therefore we want that 12 work week clock to start ticking, right? So I want to make sure that any time away ends up being designated as FMLA so that then the employee cannot come back and be like, oh, I want a fresh start of 12 weeks, right? Then I'm also going to have to engage in the ADA process. I am going to have to determine, well, okay, the restriction is a 10-pound restriction. Can I accommodate this? Can I temporarily put Mary in the office instead of the warehouse? Maybe she can be answering client calls instead of lifting boxes in the warehouse. If I'm not going to be able to accommodate that, then I might put her back on leave and require the rest of the FMLA to be taken, right? Another thing that could happen here is, let's say that as the employer, I try to find Mary a job that is going to be consistent with her 10-pound restriction. And I say, Mary, we're going to put you at the desk just answering phone calls. And Mary says, no, thank you. I'm good. I don't want to do that. Sometimes I get employers who come to me and say, well, that's frustrating. She needed an accommodation. We gave her an accommodation, and now she's saying no. Can we fire her? Well, if she still has time left on FMLA, and under this particular scenario, she does, right? Because she's only used 4 weeks. She's entitled to say, no, I don't want to do that. I'll just use the rest of the 8 weeks, okay? So I get the frustration, but you cannot fire her for not accepting the light duty assignment while she still has FMLA because she can choose to just use the remaining 8 weeks of FMLA. All right, our last scenario, Lauren.
Susan has been on medical leave of absence for 12 weeks. While on leave, the business underwent a reorganization, and her position was eliminated, with her peer assuming her responsibilities as part of the company's cost-saving strategy. Susan does not yet have a return to work date, but she thinks in 6 to 8 weeks she should be able to return. What do we do?
So Susan has been out the 12 weeks, and we will assume for purposes of this exercise that she was eligible for FMLA. So she has now exhausted her 12 weeks of job-protected leave, which means she's not entitled to any more protection. Now, we know that under the FMLA, where you take leave, you are entitled to come back, right, to the same position that you had or to one that is virtually identical, meaning that we cannot really do any substantive change to your position and we cannot deprive you of your position upon your return. However, an employee is not immune from reorganization simply because he or she has taken FMLA. Now, the challenge with this scenario will be proving that the reorganization had nothing to do with the fact that she took FMLA, meaning that it was not retaliatory. And to accomplish this goal, you will need documentation and data showing the basis for the reorganization. And of course, if Susan was the only person impacted by the reorganization, that is going to be more challenging for you as an employer than if Susan was one of many, right? Because it's going to be harder for Susan to wave the retaliation flag if a bunch of other people were impacted. Here, you will also need documentation as to why we gave, when the positions merged, why did we give the position to her peer instead of Susan? So you might want to look at, performance documents all of that stuff before you make that decision, because if Susan was potentially performing better than her peer, it's going to be very difficult for you to justify having merged the positions in a way that Susan was the one that lost the job. Now, what else can you do here from a risk mitigation standpoint? She's losing her job, and she's not yet ready to come back, but she thinks she'll be able to come back in 6 to 8 weeks. So another thing that I would recommend doing from a risk mitigation standpoint is seeing if there are other positions, other vacant positions within the company for which she may be qualified. And if she is, I will let her know, hey, Susan, we're eliminating your position, but there are these other 10 positions available in the company that you may be qualified for. We're going to give you X time to apply for them and see if you qualify, or if you end up being selected for any of them. And that will mitigate risk, because it will help show that there was no retaliatory animus, and that, because obviously if we were trying to retaliate against her, we will have just fired her, right, instead of now giving her other opportunities. So the bottom line here is that she's not immune from the reorganization. Her position can be eliminated, but you are going to have a strong data justify why you did that and why her peer got the job. And I will also encourage you to find other positions within the organization that she may be able to place in, so as a risk mitigation tool. Now, I know we're almost out of time. I think there is another poll, and then once we do that poll, we can answer questions for a few minutes, if that's okay with everybody.
Perfect. Thank you, Rocio and Lauren. That was amazing background, and a lot of great examples and kind of use cases of employee leave scenarios and how best to handle them. While you take a moment to review the many questions, and just so everyone knows, I think we had over 500 questions come in today from the presentation. I'd like to offer you another opportunity for all the attendees to register for a demonstration of the Navigator Suite. With all of the possible pitfalls of employee leave, it's critical you don't leave your compliance strategy up to chance. Our solutions were designed to support employers like you while saving your organization time and money. I'll leave this poll open until the conclusion of today's event. So, Lauren and Rocio, have you had a chance? Any questions you'd like to respond to? And again, I'll leave this survey open, so just click yes if you're interested in the demo.
Yes, of course, we can answer. Lauren, do you have any that you're ready to go on? I'm still looking through the chat.
Oh, sorry, I was replying to a few publicly.
Okay.
And let me see.
All right, so I'll take one. Is it better for an employer to wait for the employee to finish their leave of absence before informing them of the reduction in force decision, or inform them while they are on the leave of absence, Lawyer answer, it depends. So, for example, if I know that they're just starting out their leave of absence and that the risk is going to happen and that certain employees are going to be given the opportunity to apply for other positions within the company, I am going to want to inform that employee as soon as possible so that he or she also has the opportunity to apply for those other vacancies, right? We don't want them to be negatively impacted by the failure to inform them of the risk. If the employee is just about to come back from the leave of absence, we could just, wait. So it's going to depend a little bit on our past practice, on the particular circumstances. But one thing I would definitely caution you is that if waiting will be detrimental because the employee will be deprived of the opportunity to apply for other positions within the company, then I would encourage you to reach out right away and let the employee know.
There's also a question about the number of work weeks allowed under specific reasoning. And so for military caregiver leave, it's up to 26 work weeks, and the remainder it's up to 12 work weeks. So for the reasons we discussed today, for birth or care of a child, foster child, adopted child, etc., to care for a family member's serious health condition, and then to care for an employee's own serious health condition, an employee is entitled to take up to 12 work weeks of unpaid leave. under the FMLA.
Somebody asked also, if an employee has a workers' compensation injury, are they required to be on FMLA concurrently? Does the employee have to use any paid time off hours banked under FMLA, or can they keep their PTO hours to use later? So you as employer, want the employee to be on FMLA concurrently with workers' comp. First, the regulations specifically say that if an employee is taking any time off because of a serious health condition, the employer has an obligation to designate that time off as FMLA. So you are supposed to be designating that time off as FMLA. And aside from compliance with the regulations, you want that to happen, because if you're not concurrently designating, what could happen is that the employee could be out for however long, let's say 3 months on workers' comp, then they come back, they have a baby, and now they're entitled to another 12 work weeks of bonding leave under FMLA because they never exhausted. So you could have been the employee could have been out only 3 months, but now you have effectively created a situation where they're out 6 months. 3 months on workers' comp that you failed to designate as FMLA, plus 3 months on bonding leave. And that could be detrimental to your organization. Now, as to whether the employee has to use any paid time off hours, under FMLA, you can force the employee to use accrued PTO. That's under FMLA. There are some states, though, where you're not allowed to do that. So it's going to depend on the particular state. But if we're just looking at federal law, you can require the employee to use any accrued PTO concurrently with FMLA. All right, we're out of time, but we will get all of these questions in a spreadsheet, and we will do our best to answer them all. And if you have any questions that you want to send us directly, my email is rblancogarcia@littler.com. And Lauren, your email is?
lcrobertson@littler.com.
Awesome. Thank you so very much, everyone, for your attendance. Always a pleasure.
Thank you so much, everyone. And I did note some of your recommendations for our next presentation, so I'll talk to Rocio and see what we can do.